information management public lectures give attention to exciting advances in research and professional practice. The topics are diverse, reflecting the importance and global extent of information management in today's society. For details on upcoming lectures, visit tinyurl.com/IamPublicLectures. It is my pleasure to introduce today's speaker, Janet Burt-Gerrans. Janet is a legal professional with multi-sector public administration experience spanning roles in government consulting, labor relations, and public service delivery. She is a senior investigator with the Information and Privacy Commissioner's Office, responsible for leading investigations and oversight activities. Please join me in welcoming Janet Burt-Gerrans.
Thank you very much. Thank you all for being here today. Really pleased to see some interest in coming out and hearing about our Nova Scotia's freedom of information laws. So 1994, it was a great year. I don't know how many of you remember where you were in 1994, what kinds of things happened way back then. A few things. Nelson Mandela was inaugurated the first Black president of South Africa. 1994, the last Russian troops left Germany. The IRA announced complete cessation of military operations in Ireland. The People's Republic of China got its first connection to the public internet. And here in Nova Scotia, proclaimed the current access to information law called the Freedom of Information Protection and Privacy Act. So back then in 1994, I don't know if the framers could ever have predicted the culture or how that law would evolve. I'm sure they would not have predicted that it would in fact become a verb, to foipop, which means the act of requesting access to information from a public body. An adverb is something foipopable, which is asking whether a particular record or a document might be accessed through a freedom of information request. So back in 1994, this law was proclaimed and it's been in effect since then. We're here today to celebrate the right to know, to acknowledge and recognize Right to Know Week, and bring ourselves together to engage in a conversation about what does that mean, how are we doing here in Nova Scotia. So I'm going to talk a little bit about what is the right to know, what is this celebration of Right to Know Week, why are we here today, and talk a little bit about the context of Nova Scotia nationally and internationally. And I'm going to talk more about how our office views Nova Scotia's law, how are we doing here in Nova Scotia. So first of all, I want to really thank the School of Information Management and the University Libraries for sponsoring today's event, for organizing this room, and for helping us get the word out and bringing you here today. And we're joining with people across Canada and around the world to celebrate what is really a fundamental component and foundation of a healthy democracy, and that is the right to know, exercising the right to know. I also want to acknowledge the research team at the Information and Privacy Commissioner's Office, including the Commissioner herself, who have gathered together the information that I'll be talking about today. Staff from our office are delivering this message at post-secondary campuses across the province this week as part of celebration activities, and we are joining with Information and Privacy Commissioner's offices across the country, and again, various organizations, non-governmental organizations, and other oversight bodies around the world who are observing this week. So for any academics in the audience, any references, I know this is really important if you're academically minded. I'm going to be talking about some various different contexts, facts, some statistics. It's not to kind of be heavy on that side, but if you have an interest in knowing the references and where all these things are drawn from, of course they can be made available to you. I'm not going to spend a lot of time on that when I'm speaking, but I'm happy to make that available following the presentation. So first of all, just a really unscientific quick show of hands. How many folks have heard of the Information and Privacy Commissioner's Office? Wow, we are doing really well in this room. When oversight bodies ask that question of, diverse audiences around the world, they tend to get a response somewhere in the 50 to 75% range. So we're doing really well in this room. Maybe this is a group of really well-informed citizens, but we're really glad that you're here and we're in good company. So we are one of 15 information privacy commissioners across Canada. There's one in each province, and there are in fact 2 at the federal level. It's split into the information commissioner, who currently is Carolyn Maynard, and the privacy commissioner, who is currently Daniel Tello. At the federal level, and they are responsible for oversight of the federal access to information and privacy laws. So the role of our office, not to be confused with IAP services, which stands for Information Access and Privacy Services. That's a branch of the Department of Internal Services with the provincial government that are responsible for processing access to information requests. Our office, the Information and Privacy Commissioner's Office, is responsible for impartial oversight of public bodies and their compliance with access to information and privacy laws. So we hear appeals for access to information decisions. We conduct privacy investigations, and we have an education mandate. So part of our mandate is to raise awareness with the public of access to information and privacy issues. So part of our, this celebration this week and getting out and talking with people, that's part of our education mandate. Some of the other things that we do along that mandate are to produce guides and tools and documents that are both for public bodies to help them in their role of complying with the law, and for citizens to help them understand what their rights are under the law and how they can go about exercising those rights. So some of the documents that we've produced, and they are all available on our website. We produced big data guidelines, both for researchers and for citizens. We produced video surveillance guidelines. We produced a guidance document for universities doing background checks, which involves the collection and use of personal information. And we've also produced a guidance on key steps to privacy breach management. That's just a few examples of the kinds of tools that our office have produced and that are available to folks free of charge. So we're here today as part of the education mandate. We're talking about Right to Know Week and the power of access to information laws. The power of these laws lies in the fact that when an access to information request is made, a public body must respond within a limited time period, and they must respond openly, accurately, and completely. Those 3 words are actually part of Nova Scotia's laws: openly, accurately, and completely. And that's where the power of the citizen to obtain information, to hold their public body accountable lies, because the public body under this law is obligated to reply in that manner. So our role here today is to engage the public in recognizing this power and in understanding how to harness that power and how to use that power to improve the condition of our democracy and to improve the kinds of public discourse that we can have, the kinds of accountability that we can have for our public decision makers and public bodies. So Right to Know Day started actually following a conference in Sofia, Bulgaria in 2002. It was a conference of access to information and right to know professionals. Maybe not your first guess of who might have come up with this, but it was a group of Eastern European countries and professionals working in those countries that had come together for a conference and decided that wouldn't it be great to celebrate this access to information, to raise awareness and to come together to engage the public. And it caught on, and now it's celebrated in more than 40 countries around the world, including across Canada. So we're really glad to be here today. And in terms of what I'm hoping that you will take away from today's discussion, really there are 2 fundamental messages. First of all, the right to know only exists if citizens exercise it and insist on it being open, accurate, and complete in terms of the public body's response. That's a significant source of the power, and it only exists if it gets exercised. And the second fundamental message is that the right to know is fundamental to the health of a democracy. Without access to information, without citizens' ability to know what is happening within the government and using that to be able to hold governments accountable, the citizen is not part of the democracy. That within a democracy, citizens have given to government, to politicians, the right to govern within a mandate, within a period of time, and the right to know what that government is doing is fundamental to the citizens' ability to evaluate whether they're going to continue to support that particular government or move on in some other way. So those are two fundamental messages that we're going to kind of come back to as we go through. In terms of context, there are over 100 access to information laws around the world. They come in different forms. They use slightly different phrases and terminologies and languages, slightly different guarantees, slightly different approaches, but all fundamentally geared toward ensuring and enshrining the right of access to information for citizens. That it's a right that is engaged and exercised by citizens for the benefit of public discourse and the health of democracy. So it is something that has become really important in new and emerging democracies. Sometimes in new and emerging democracies, they choose to enshrine these rights both in legislation and in their constitution, so that a government can't then change the law as at its whim. An example of that would be Tunisia. Access to information exists so that citizens can know what the government is doing, how decisions are made, what personal information of their own is held, and how it's being used and how it's being safeguarded. Those are important parts of the access to information law. Access to information laws have been increasingly adopted specifically to combat government corruption. And this is part of India's story. When India enacted its first access to information legislation in 2005, at that time, the legislation from India was actually hailed as a radical piece of legislation. That it was, and this is India's law minister in an interview reported by the Guardian newspaper, called it a total paradigm shift from a regime of secrecy to one of transparency. So at the time, the government made a decision that they wanted to have this piece of legislation, that it was an important part of strengthening the democracy that was developing in India at the time. And it did require a real shift in the mindset of the public body and public officials to be able to operate under this new law. Citizens took it up in great numbers. And so I'm going to share a story of one citizen in India who really has become a symbol of courage and unwavering belief in the ability of one citizen that a dedicated citizen can hold their government accountable through their access to information requests. So this story is about a citizen named Shashidhar Mishra. So this individual who was a regular citizen, he was a street vendor in Baroni in northern India. By night, he was a citizen accessed, making hundreds of access to information requests. So he was particularly interested in the use of public funds and the award of public contracts. And so had made lots of volumes of requests, and I guess had become quite known within the local area. Unfortunately, this story ends badly for this citizen. In 2010, he was gunned down by motorcycle riding assassins using a handgun with a silencer. And the interesting part of the story is that he was sitting on the stoop of his home, and the street lights mysteriously went out just before the assassins pulled up. The assassination took place, and then suddenly the street lights all came back on. So there certainly were questions about who might be responsible for that act. It's not an isolated story, but this particular story has become a bit of a symbol for understanding how important it can be for citizens to take up this power, but also how challenging it can be, and particularly for folks who are going through that paradigm shift from secrecy to transparency. It's a real change in how one approaches the relationship with citizens. And that's not to say India is in that place today, but at that point in time, it's well reported, the occurrence. But at the time, in 2010, that area of India was receiving about 100,000 requests in 2010, that year, from that region of India. So the citizens really were taking it up and holding their government accountable. It wasn't necessarily a smooth transition and wasn't always a great outcome, but it's part of that story and part of the development of a civil society and a context for access to information and transparency. For newer democracies, it can be difficult for individuals to make that paradigm shift. In more established democracies, sometimes it's a different kind of challenge. Sometimes it's a challenge to engage citizens, to see that this power and this right exists and that it might be useful to use it. Sometimes it's hard to get people to come up to a talk like this and hear about it. Maybe people already know about it. But it's something that our office has taken on as part of our mandate, and so we're very happy that you are here today and that you can help us engage others in the conversation, and partly want to celebrate what we do have and use it to its best effect. So part of that international context, again, looking at actual laws across the planet. So it said there are about 100 access to information laws. We've got a local NGO, the Center for Law and Democracy, that has a rating rubric. And they've rated access to information laws based on the words on the page. So the actual structure of the law. Interestingly, India's law scored 130 out of 150 points possible. They scored very high in terms of the structure and the articulation of the law and the rights and the guarantees. And I think this is why the law minister at the time called it a paradigm shift, and it was viewed as this radical piece of legislation at the time. So you're wondering, where is Nova Scotia on that? Any guesses? Any guesses? How would Nova Scotia's law rate? Anybody wants to go out on a limb?
On paper or?
On paper. On paper.
On paper, toward the top. Yeah.
You might be surprised. 1994. So that's the law that we have today. It's the 1994 law. And the Center for Law and Democracy has rated Nova Scotia's law at 85 out of a possible 150. And to put that into some context, the Canadian federal law was rated at 90 out of 150. Switzerland, as an example, 77. Austria, 39 out of 150. So India actually scored very high in terms of what is enshrined in its piece of legislation. But as I said, paradigm is really important. And the law itself only provides the framework within which the rights get exercised. So if we want, we'll just compare for a minute that paradigm. So I said Switzerland was its law was rated at 77 out of 150. Nova Scotia was rated at 85 out of 150. So fairly close in terms of how our pieces of legislation look on paper. But if we look at a little bit more closely at some of the other statistics coming from these two jurisdictions, they're not totally uncomparable. So Switzerland has a population of about 8.3 million. Nova Scotia, we're just under 1 million, so we're a smaller jurisdiction. In 2017, Switzerland processed about 551, or they reported that they processed 551 access to information requests. In Nova Scotia, the Nova Scotia government, specifically the provincial government, reported that it processed 2,285 access to information requests in 2017. It's quite a few requests for a smaller population. The results. So just looking at two specific result categories. So when a result or a decision on access to information request comes, you get records that are disclosed to the applicant. So in Switzerland, they found that they reported that in 55% of the cases of the access to information requests, 55% were full disclosure. The documents can go out full. There's nothing that needs to be redacted. In Nova Scotia, 14% of access to information requests resulted in full disclosure. And another category of stats, so in Switzerland, they found, or they reported, that in 10% of the access to information requests, it was resulted in an answer of no records were found, 10%. In Nova Scotia, it was 33%. So these statistics, the full disclosure and no records found, they don't speak to what's on the page. Really, they speak to how access to information requests are processed and the paradigm and the approach of the public body across the board. So in terms of full disclosure, we might talk about a paradigm of default to disclosure versus searching for exclusions and reasons to withhold information. When we're talking about no records found, we might talk about a paradigm of duty to document versus an approach that is maintain minimal documentation. And those are approaches of government that are not specifically addressed within our legislation and in some legislation. So if you're in the 150 range of the rubric from the Center for Law and Democracy, you have much more explicit requirements for the duty to document, for example, and for various other paradigm approaches. That's not where Nova Scotia is at the moment. So it does make us wonder, and this is really just musing on what are we looking at here, and wondering whether these kind of results, when we compare Switzerland with Nova Scotia, where full disclosure 55% of the time, no records found only 10% of the time, but only 551 actual requests. Nova Scotia, 14% of the time we got full disclosure, and 33% of the time there were no records on 2,285 requests. Musing and wondering, is this part of the relationship between citizens and their government? Is there a trust that's built when there is transparency and full disclosure and documents are found? Perhaps citizens are more comfortable with their government, perhaps they're trusting them more, and they're not making as many requests. They don't feel the need to make as many requests. And we compare also with the example I talked about in India, where in those early days of their radical new legislation, in that one region of India, what did I say? It was 10,000 requests. Sorry, no, I'm wrong. It was 100,000 requests for access to information from that region of India. That's a citizenry that does not trust its government very much and is using and exercising the rights and the power that are available. And perhaps that's something that can change over time. As a democracy becomes more established and as citizens develop trust in their public body, we can see how the paradigm plays out, which is independent of the law and how it's written on a page. So, how really are we doing here in Nova Scotia? Like many laws across Canada, our law is badly outdated, but it still serves its essential purpose. Citizens can make access to information requests. They do it every day, and they do receive responses from public bodies. Maybe I'll just pause for a second and just infuse a bit of information about who are we talking about? Public bodies, just for those who are not that familiar with the law. Public bodies that are under the Information Privacy Commissioner's oversight include the provincial government proper, so that's all our departments within the provincial government, includes agencies, boards, and commissions that are that can meet the test for being a public body under the Act. It includes universities, and we also have Municipal Government Act that applies to municipal governments, municipal police forces, and there are a variety of other smaller public bodies, the Workers' Compensation Board, for example. There are just a range of other smaller ones. Some are designated in the regulations. That gives you a good sense of the broad categories of public bodies that are covered. So we here, our office, receives and hears hundreds of appeals of access to information decisions every year. We frequently hear complaints about delays, severing. That's when the record, before it goes out, gets parts of it blanked out, grayed out. Public body decided this can go out, but not this little piece, or this piece over here, and not this piece. So yeah, we hear complaints about delay, about severing, and about fees. Those are probably the three biggest things we typically hear complaints about, and the nature of the appeals to our office typically have to do with those three areas. So based on the experience of this jurisdiction, our commissioner's experience in other jurisdictions, recommendations were made last year, June of 2017, and I'm going to shamelessly promote Accountability for the Digital Age. This is a comprehensive set of recommendations to the Government of Nova Scotia to modernize Nova Scotia's Freedom of Information and Protection Policy legislation. And in fact, it is a bit more complicated than that. There are actually three pieces of legislation that come into play. The Freedom of Information and Protection Privacy Act, there's the Municipal Government Act, which mirrors that as it relates to municipal bodies. There's the Privacy Review Officer Act, which gives them the commissioner her oversight role, and then we also have another act, the Personal Health Information Act, which has a slightly different application. It does not apply to freedom of information requests, but it does apply to how personal health information is gathered, used, and disclosed by custodians. That's a topic for another day. I'm not going to talk about that too much, but there are some references to that and to the suite of legislation that our office is responsible for. So, in terms of accountability for the digital age, what do we mean by that? Well, this law was drafted in 1993, came into effect in 1994. At that time, there were about 130 websites. Now there are over 1 billion websites. Google did not exist and was not a verb. Google was founded in 1998. Facebook didn't exist. That came into existence in 2004. Big data was not a concept. The concept of gathering data into large amounts where artificial intelligence and computing and analysis is being done to solve problems, to find patterns, to do all kinds of things that we do with big data, but that didn't exist when this law was drafted and was enacted. The world is a different place. And although there are components of our law that can still serve the essential function, there are some aspects of the law that just are not up to the task of today's reality. And that's what these recommendations really are all about, pointing out and offering solutions to. So in terms of what are those problems and solutions? So we've really got them broken down into 4 areas. First of all, access problems, access to information, problems and solutions. So time. We often hear from public bodies that it's very difficult to meet the time frames that are set out in the legislation. We hear from applicants that it's very frustrating that they don't get responses within the time frame set out in the legislation. So our commissioner's recommendation and answer for that is that part of the answer lies in the format of the records themselves, having them be in a format that is easily searchable, that is indexed, that that is properly managed from an information management perspective, that it's easier to find things when they're stored and organized. And the second part lies in a more robust duty to proactively release information. So this goes back to that paradigm shift of, are we defaulting to releasing information, or are we defaulting to, we withhold information except where we are forced to, or we're looking for reasons to withhold. That takes a lot of time when you have to go through a document and read line by line and try to understand and figure out what exemption under the Act could apply to this sentence and what exemption under the Act could apply to this sentence. It's very, very time consuming. And so our Commissioner's answer to that is that that's a paradigm and approach that's really not necessary. It's not actually totally supported by our Act. Our Act does set out a default of disclosure, except where certain exemptions apply. In terms of duty to document, this also would assist with time and access problems, particularly around access to information requests that result in no record found. Many times citizens will come to our office, they can't believe that they've asked for something that should exist, that a common sense would say exists, but yet the answer is this document doesn't exist, this record doesn't exist. Or maybe it doesn't exist in that particular form that it's been requested. We don't have notes from a meeting, we have minutes from a meeting. We don't have minutes from a meeting, we have notes from a meeting. So those are, so a duty to document and to organize things in such a way that they're easily accessed is really our Commissioner's recommendation and suggestion to resolve some of those issues that contribute to the challenges of processing access to information requests. She also recommends that we remove the $5 application fee as a barrier. Other jurisdictions have tried this. Newfoundland, I think, is one of the most recent ones in Canada, and they have seen an increase in their access to information requests. So that demonstrates that it is a bit of a barrier. Whether or not the government may contemplate that. The flip side of that, though, is also fees charged to produce records. So photocopying charges and delivery charges can be extremely expensive. We've seen some quite high fee estimates. So another area that is recommended that we look at modernizing the law is that this law does not contemplate records being produced in electronic format, which don't carry the same kind of costs associated with producing paper records. And could potentially reduce the kind of administration involved. So it's certainly something that we recommend. Sometimes public bodies follow our recommendations, and sometimes that's a way that we can assist to resolve particular scenarios. If a public body agrees to produce a record in an electronic format, so there's no photocopying charge, there's no mailing fee, but sometimes they don't agree to do that. And this law does not address that at all. It doesn't address the format options for delivery of records. So the second, I'm just being mindful of time, so the second big area of sort of problems and solutions that are addressed by the Commissioner's report, first of all, in the privacy area, Nova Scotia lacks a lot of the essential modern privacy protections that are found in laws drafted really in the last 5 years. The privacy protections in the Freedom of Information Protection and Privacy Act really come down to about one line that says that the public body must have reasonable security protections in place. And that's a concept that is sufficiently malleable that it does evolve as time evolves, and we're looking at different kind of sources and best practices and what has developed. But it's also a fairly vague standard to hold a public body accountable to, and so that's an area that the Commissioner has recommended some modernization. Big data is a big area of concern for our Commissioner, and an area that is really not addressed at all by the current law. Big data, as I said earlier, is really when large data sets are gathered together. Often they are put together with other data sets so that information can be analyzed. It's a very powerful tool, but the current law does not sufficiently describe how that should be done. What kind of consent do citizens need to provide in order to have their personal information be part of big data sets? What kind of de-identification should be taking place? And so there are a host of issues that come from the concept of big data and ethical use of personal information and personal data. Again, the Act just is not drafted to address these kind of modern considerations. An example of a very modern initiative involving the collection and aggregation of large amounts of personal data is the current provincial government initiative to create a facial recognition database from citizen driver's licenses. So this is something that's happening right now. There is some vague information available on the provincial government website. The next time you go to renew your driver's license, it will be a slightly different format, and it will come to you by mail from a company that's actually located outside of Nova Scotia. And your photograph will be used as part of a facial recognition database. Our law does not specifically address how that should be done, or even if it should be done, what kind of parameters should be placed on that, who should have access to that database, will it be available to security agencies, police, we don't know. So these are some areas where the technology is advancing and the current law is just not up to the task. So I don't want to go too much further down that road. Privacy is a whole other aspect of the law. It's not specific to access to information, although as a citizen you can certainly request access to your own personal information so that you can know what the government has in terms of your information, how it's stored and how it's being used. And you can also request information about programs like facial recognition or other kinds of privacy protections that the government has in place. Those can be the subject of access to information requests. Okay, so one more area in terms of, problems and solutions, then we're going to move on and open up for some more discussion and questions. So more broadly, our commissioner in her report identifies some concerns and some problems and recommends solutions with regard to oversight in general and how the office itself is situated and can function and carry out its role and mandate. So she recommends, first of all, that the commissioner be made an officer of the legislature. So currently, the office is actually situated under the Department of Justice. The commissioner's annual report is tabled in the legislature by the Minister of Justice. And you might wonder, how does that work when the Department of Justice is also a public body that is subject to the oversight of the commissioner? We're still scratching our heads on that one. So this is the reason that the Privacy Commissioner has made that recommendation, because being an officer of the legislature means that she would be reporting directly to all of the members of the Legislative Assembly. And it's an important part of solidifying the independence of the office from the public bodies that the office is charged with overseeing. It's a really important part of ensuring independence and control over the appointment of staff, the budget of the office, and the reporting structure of the commissioner herself. The second major oversight issue that the commissioner has identified is really the nature of the power that is held by the office. So currently it is a recommendation-making power. So under all of the pieces of legislation that our office is responsible for, we have the ability to make recommendations to public bodies. if a public body chooses not to take up or follow a recommendation, depending on the nature of the situation in front of us, the citizen, it's an access to information request, for example, the citizen then has the option to appeal to a court for judicial review of the public body's decision-making. It would be a trial de novo, which means that the court would hear all of the facts, do all the findings of fact, and would hear the case fresh. But it places a pretty significant burden on the citizen to then take the government to court in order to have their issues heard. And so under the current legislation, the commissioner is not party to any action of that nature, although there was an applicant who was successful in doing that just last summer. This is the fish case. Received act, and in the end, the court actually did concur with the commissioner's recommendations, and at that point ordered the government to release information that had been withheld. So the commissioner actually recommends, there are a couple of different ways that can be addressed. Full order making power is one of the options, and there are some examples across the country. So British Columbia is a very good example of a commissioner that has full order making power. Excuse me. Our commissioner has not actually recommended full order making power. She's recommended something that's slightly different than that, because it's a small jurisdiction, a small office, and there is some value to the ability to be a little bit more informal. So she has rather recommended the kind of approach that they've recently taken up in Newfoundland, which is that it is maintaining a recommendation-making power, but it's changing the burden so that if the public body chooses not to follow the recommendation, rather than forcing the applicant to go to court, it forces the public body to seek the approval of a court not to follow the recommendation of the commissioner. So it's a little nuance on recommendation-making power. What it does in effect, and certainly Newfoundland's example gives us this experience, is that it changes the burden, first of all, onto the public body to seek judicial review if they choose not to follow the commissioner's recommendation. But it also changes the dynamic and places quite a bit more incentive on the part of the public body to follow the recommendations that are being made by the commissioner. Whereas today, it's recommendation-making power, the burden is entirely on the citizen, and there's very little in the way of consequence or incentive for the government to follow recommendations. Sometimes public bodies do follow recommendations, many times they do not. So one last area of concern and sort of problem per se that the commissioner has made a recommendation about, and that is really, I alluded to earlier that there's a suite of legislation, and so her recommendation is that the legislation should be brought together under one piece of legislation, so that number one, it's not so confusing for citizens who are making access to information requests. They think they're under FOIPOP when really they're under the Municipal Government Act, and sometimes it's different forms, and sometimes the public bodies can be very sticky about what form you use. So in terms of making it easier for citizens to navigate and to understand what is available to them, but also in terms of ensuring consistency, there are actually some inconsistencies. The Municipal Government Act was intended to be a mirror of the Freedom of Information Protection Privacy Act, but there are some very nuanced details that are inconsistent in the two, and that sometimes causes confusion and challenge as well. And then the third is the Privacy Review Officer Act, which was in a sense an add-on. It came later, and it really gives the Privacy Commissioner the ability to conduct privacy investigations and to have oversight over the privacy part of the Act that is not actually in the original 1994 Freedom of Information Protection Privacy Act. So this brings us full circle, back to 1994. It was a great year, great things were happening around the world. We brought into Nova Scotia this great law that gives us all the ability to, and the power to hold our government and our public bodies accountable. As I started out saying, the fundamental messages that I'm hoping you'll walk away with are that number one, access to information and the ability to request information from your public bodies is fundamental to a healthy democracy. This is part of how transparency occurs. This is part of how we can know whether our public bodies and our politicians are living up to the promises that they've made. And the second of my fundamental messages is that that right and that power exists only when citizens exercise them. So again, I thank you so much for coming today and for your interest in hearing about this. I hope that I've given you something that maybe sparked curiosity, or you're going to walk away with interest. We do have about almost 15 minutes that I'm happy to entertain questions or comments. I'm sure we can have some really interesting conversation. I've got some right here already. Great.
Prior to 1994, the vast majority of municipalities in Nova Scotia were required to provide information on request. And there was a section in most municipal legislation, except for the city of Sydney, the city of Dartmouth, and the city of Halifax. There was a section there that said the books, records, and accounts shall be open to inspection by any person at any time. Dean Job was prior to the legislation, we're often writing about this need for FOI. And I was like, I wish you'd shut up about it, because there already is an at the municipal level, there already was. So if you go back to the Towns Act and other, I went through all this a long time ago. Sometime in the mid-80s, I was reading a lot of municipal legislation. And there was a famous case where a Halifax citizen in the 30s, I believe it went all the way to the Supreme Court, where he would regularly go down to City Hall and ask for information and documents related to certain affairs. And the gentleman, the engineer in charge of the water, went to two conferences, and this citizen took objection to it on the grounds that he wasn't entitled to be, the legislation didn't entitle him to be reimbursed for certain expenses he incurred. The gentleman won it at the lowest level, won it on appeal. And it stood on the books for a long time. I used to read Rogers' municipal reports, and I think the worst part of it now is that as Dartmouth went from a town to a city, the city charter didn't include those sections that had previously applied into the Towns Act. And so in a way, I'd like to go back to those days at the municipal level, where you could just waltz into any department, except I would say the police department, which is an entirely separate piece of legislation. You would go in and ask for information, and you have the statutory right to that information. So there was none of this point off and I don't objectify it. There's none of that. You could just go in and say, section so-and-so, so-and-so, gives you the right to have this information.
And I think maybe you're tapping into that there's an evolution over time, that these concepts have been in place in various forms across Nova Scotia, across the country for a very long time. In fact, Nova Scotia was one of the first jurisdictions in Canada to claim an access to information law. I think it was 1975, an earlier version of the current law. But I think that sort of part of the answer, I don't know if it was a question exactly or a comment, and I appreciate your comment. Part is that, number one, the access to information laws that we have frame the ability to request information very, very broadly. So you're not entitled to X, Y, Z category of documents or records. You're actually entitled to any record in the care and control of the public body, subject to some limited exceptions and exemptions. And by framing it in that way, it's actually qualitatively different than a right to show up and say, I want to see the books, because you might not know what is there to ask for. And I think the other way that things have evolved that perhaps offer citizens a bit more than what may have been on the books previously is really in terms of by broadening out to a provincial scheme that applies across the board, it certainly allows for dynamics in smaller rural areas not to win the day. And I would just point to a couple examples. It was maybe 2 years ago now, a year and a half ago now, we had some citizens that were seeking some receipts for expenses from some small rural municipalities. Through the process of seeking that information, actually uncovered some not very good practices that eventually resulted in some changes to the Municipalities Act. Those individuals were emboldened. They took the power to request that information despite what the municipality was telling them that they were entitled to. And you know, there were some courageous individuals who really took on some of the challenge and some of the pushback that they received in their small communities. But the ability to have that be across the board, that there's somewhere that you can go to appeal decisions, that allows for the exercise of that right to then be effective. So I think that's, you know, there is a history in Nova Scotia, but it's a history that's evolving, and we're hoping that it's going to continue to evolve and keep up with modern life. Please.
So the commissioner has made recommendations. How receptive is the government to actually revise the act? Do you have a sense of that?
Well, I can say that this document was sent to every member of the Legislative Assembly. It was published in June of 2017. To my knowledge, we have received no formal response to the document. We certainly are talking about it. We certainly are seeing some more public discourse in recent months, weeks of this nature. It appears that you know, people are becoming interested. We're going to continue to talk about the recommendations that are actually made in this report. And so I guess I'm not really able to give you a specific answer other than to say we've had no formal response to this report. And the report, although I am carrying this nice paper copy of it, is available for download free of charge from our website, or you can obtain a copy from our office. Yes, please.
So, just with some of my experiences with working with water processes in the province, while, well, right now it's not as accessible as it was, but in the, at least for the provincial departments, there was that nice portal that existed and that had issues. Basically, I'm just kind of wondering about the sharing and standardization of how information is presented, especially with entities that are under various categories of this kind of freedom of information legislations. Like even thinking to the proactive release table that you also have for the various entities, various public bodies and stuff, that you know, help the public if they want to find information. Like just looking at the municipality section of that, and you have the town of Amherst, the town of Hawkesbury, Kentville, and Yarmouth. All of those have the same kinds of expenses, i.e. councillor expenses, councillor and CAO, and other kinds of expenses presented in quite different ways. And so basically I'm just coming at it from more of a information management perspective, but also just like a kind of interchangeability perspective. Like what can y'all do as the office to try to like be like, hey, we recognize and identify that municipalities have these kinds of common information presented. what can we do to try to make it so all are identifying the same kinds of information, which would again help with it. And then a kind of similar, like, just with the other public bodies, like even if I do make information requests, at least there isn't generally the habit of like publishing those requests in a public-facing way, like the province does. I'm thinking back to a couple of the universities in the province. So
Yeah, so
like,
it's a good question in terms of the kinds of results from, I think your question maybe touches on two things. One is that kind of proactive disclosure. So there's another bit of a movement called open data, which is really encouraging governments to become proactive in their release of information so that people then don't even have to go through an access to information request. When they choose to do that, I think what you're finding is that it's sometimes hard to compare what's being released, even if it's nominally it's the same information or the same types of information, but they're presented in such different ways that you can't really compare it, you can't really, it's not as easy to analyze what you're seeing or even read what you're seeing maybe in some cases. So I guess on that level, open data is certainly a concept and a movement that privacy or information privacy commissioners across the country are supportive of. We think that it really helps with transparency. It certainly has the potential to help public bodies respond to access to information requests, because if the information is already out there, then they don't have to request it. You don't have to go through that process. So although it is related, it's not at all governed by the access to information legislation. Our office does not have an oversight role, although I'm aware of folks like the Center for Law and Democracy being involved in trying to get governments, when they sign on to open data, to also agree to use certain kinds of formatting. As far as I'm aware, that has not produce the kind of results that maybe as a citizen you're hoping for, and understandably hoping for. But at the end of the day, if governments sign on to open data, privacy commissioners are much more interested in having them sign on wholesale, and they get open, accurate, and complete disclosures than to, at least at this stage, to get too detailed about what's the format of that, although recognize that from a citizen's perspective it would be really useful if it was. And then I think the second part of your question or comment was really asking about when you go through an access to information request. Help me recall what
so
you said.
basically, like, I've made access to information requests specifically to universities, but I guess I think public bodies which are more away from government name, and like they just don't have a kind of like there's no repository of where those are being collected that's easily accessible.
Okay.
As far as I understand, with the university, they'll specifically identify the file. Another FOIA request for all FOIA requests made in the past period.
Right.
And for
Okay. And so this is another component of kind of open data. Is when one citizen requests something, then a public body makes the decision that, okay, rather than asking any other citizen that might be interested in that information, forcing them to also request it, we're just going to publish everything that that can be published. And then there are certain areas where it would not be appropriate. For example, if it contains personal information. Government is and public bodies are responsible for safeguarding public information. And so there are some components that need to be taken into account. But making that decision that if it's a document that can go out, it's got general information, rather than making others request it as well, it's part of that open data initiative. So the provincial government did really take a very forefront of the pack, sort of an avant-garde approach in setting up the portal that you referred to. So this was a portal where individuals could make electronically access or request their access to information. And as part of that, there was and there still is, that part is back up and running as I'm been told, the former requests are available to anybody online without making an access to information request. Things that have been disclosed to other applicants are made available to everyone in the public. And so it's part of that open data. I think it's a great initiative. The Privacy Commissioner certainly supports that as a way for public bodies to make that paradigm shift to defaulting to disclosure. When can we disclose rather than when should we not disclose? When can we disclose rather than, ooh, what do we not want to let out? So it is part of that paradigm shift, but it is also not a component of the current legislation at all. So the decision to do that is entirely with the public body. There is no ability on the part of the commissioner to really recommend or ask public bodies to take that approach. So that's, it certainly is part of the landscape, but it's not strictly part of the legislation. Okay, I think we'll probably take one more question. I'm been told there is class coming in here at 1 o'clock, so I will be available. I'll be hanging around in the hallway afterward if people have other questions, but yes. Okay, sure.
I think we're going to mention the same thing anyway.
Okay.
So you had made the comment about the purpose of the Freedom of Information and Access laws. Part of it is to kind of check in on the government and see, hold them accountable for things. The problem with holding, I guess, politicians or ministers accountable for their actions, or specifically the advice given to them by the deputy ministers, and vice versa. One of the exemptions under the Freedom of Information Act, Section 14, is just a general blockade on everything, any advice given to a minister or deputy minister. This was something that was added in 1994. It's hard for me to reconcile, having access to information and seeing and checking up on politicians, but also I can't actually know anything they were told. So it seems like a gaping hole in our act that needs to be looked at. I'm just curious what your thoughts are on that.
Yeah, I think that the commissioner would agree with you that some of the exemptions that currently exist in our law are either more broad than they need to be, or are being utilized in a manner not contemplated by the Act. And so one or the other of those two things could be happening. That particular exemption that you mentioned is one that we see quite often in appeals, that people will receive a document that's got all kinds of things redacted using that particular exemption. And so we will engage with the public body around what does that mean. And I think the way that exemption is actually worded in the Act, it gives some examples of what is meant by advice to the minister, and sometimes what it's being applied to is quite a bit broader than what is actually contemplated by the Act. So there are two aspects to the response to that. One is our role is to hold the public body accountable and to be compliant with what the Act actually says, not what they might wish it says. And then the second is that perhaps that's part of what Nova Scotia might want to consider as it goes through a process of modernizing its law. That's one of the aspects that would certainly increase the rating that Nova Scotia's law receives from that Center for Law and Democracy. I said earlier we got a rating of 85 out of a possible 150. That's where the points are, is in the kinds of exemptions that we have. How is the exemption actually articulated? And is it narrow? Is it specific? Are there wiggle words? Can you use it more broadly? Those are the kinds of things that we certainly would look at. And if we were asked for our advice, we would advise the government on how an exemption like that might be drafted, or whether or not that exemption is even needed. And that's part of the debate of what do Nova Scotians want to see for the law.
That was one that's come up a lot with the, I guess, the portal being down. There's a lot of advice to ministers and vice versa that didn't make a lot of sense to any outside observers, but they're unable to see the reasoning behind those decisions.
Yeah, and it does make it very difficult for an applicant when you receive a document that's got all kinds of things grayed out, and all you have is an exemption number, and you go to the act and it says, this was redacted because it was advice to administer, for example. You can't know, and that's partly what our role is if you come to our office for an appeal, our office will, first of all, get access to the whole record so that we can evaluate whether or not what's in the record meets what the exemption was designed to apply to.
That's recently been proved not to be true.
Well, it's true that our office does make recommendations that sometimes get followed and sometimes do not.
Just saying.
I fully agree.
I think we're all on the same side of this.
Yeah, no, good discussion.
On behalf of the School of Information Management and Dalhousie Libraries, I would like to thank you for coming in to speak with us today.
Thank you very much.
It's been a
Thanks for
pleasure.
having me. I'll just, while you're still here, I'll make one more plug for celebration activities. There is a trivia night at the Board Game Room and Cafe, which I understand also serves beer, 7 to 8:30 p.m. on Wednesday, September 26th. So if anybody cares to come out, it will be fun, I'm sure. The commissioner will be there and test your trivia. This is a very knowledgeable group. I'm sure you'll do very well. Thank you so much. Oh, I do have executive summary.